Welcome and good morning, good afternoon, and good evening um, to the EU-UK Trade and Cooperation Agreement and its implication on investor-state dispute settlement event. This event today is presented by the Arbitration Report Board of Reporters and the Academic Council of the Institute for Transnational Arbitration of the Center for American and International Law. My name is Chiara Giorgetti, and I'm a professor at the University of Richmond Law School and the chair of the Academic Council. I'm joined today as moderators by Dr. Monique Sasson, who is a co-managing editor of the ITA Arbitration Report at kluwerarbitration.com and of counsel with DR Arbitration and Litigation. Dr. Sasson has more than 20 years of experience in international dispute, and has particular expertise in international investment law. She's qualified as a New York attorney and English solicitor and an Italian avvocato, and holds a PhD in international law from Cambridge University. Dr. Krina Balta, who's a senior lecturer in international arbitration at Stockholm University and a qualified attorney at law with extensive practice in various aspects of international dispute resolution, and she acts in numerous arbitration as sole arbitrators and co-arbitrator. Krina is a member of the Stockholm Chamber of Commerce Arbitration Institute Board and a prolific author. She's the co-managing editor of the ITA Arbitration Report, a member of the ITA Academic Council, and the editor of Kluwer Arbitration blog. She's also co-managing editor of the ITA Arbitration Report at kluwerarbitration.com and a member of several editorial boards in journals in the field. Krina holds a PhD in international arbitration from Queen Mary University in London. We are joined by four highly knowledgeable and expert panelists, whom we thank for joining us today. First, Professor Luca Mistelis, the Clive Smith-Rowe Professor of Transnational Commercial Law and Arbitration at Queen Mary University in London, and former director of the the School of International Arbitration and the director of the QMUL and UNIDROIT Institute of Transnational Commercial Law. He practices as arbitrator and an expert in arbitration proceedings from his own boutique consultancy firm. He was educated in Greece, France, Germany, and Japan, and is a fellow of the Chartered Institute of Arbitrators. He's also a prolific author, and his publications include 8 innovative empirical surveys on corporate attitudes towards dispute resolution. He's also a member of the Academic Council of the ITA. Next, Professor Dr. Eric de Brabander, who's a professor of international dispute settlement law and director of the Grotius Center for International Legal Studies, and member of the ITA Academic Council. He's also an attorney at law at the Brussels Bar, practices international law and investment arbitration. He's the editor-in-chief of the Leiden Journal of International Law, a member of several board of editors in prestigious journals. Professor Maria Beatrice Deli, who teaches at the University of Molise, is a partner at DR Arbitration and Litigation. Professor Deli is specialized in international commercial and investment arbitration law and complex litigation, and is acting as counsel, secretary, and arbitrator in complex international cases in both ad hoc and institutional settings. Maria Beatrice is the Secretary General of the Italian Association for Arbitration. She's the Secretary General of ICC Italy, and she's also one of the founding members of ARB-IT, the Italian Forum of International Arbitration and ADR. And finally, Dr. Catherine Titi, who's a research associate professor at the French National Center for Scientific Research, CNRS, CERSA, at the University of Paris 2 Panthéon-Assas. In addition to be a member of the board of the European Society of International Law, she serves on the steering committee of the Academic Forum on ISDS and on the Academic Council of the ITA. She's also a member of the International Law Association Committee on Rule of Law and International Investment Law, and she serves on the editorial board of the Yearbook of International Investment Law and Policy. Catherine is also a fellow of the Chartered Institute of Arbitrators, and she sits on the panel of arbitrators of the Court of Arbitration for Art, and she's appointed to the roster of the United States-Mexico-Canada Agreements Annex 31B panelists. For a fuller biography, I will ask you to look at the ITA website. Today's event focuses on the EU-UK Trade and Cooperation Agreement, TCA, which was concluded on 24th December 2020 and provisionally applicable since the end of the transition period on the 31st of December 2020, And I understand is actually today being discussed in the EU Parliament. The DCA regulates the relationship of the EU and the UK after Brexit and forms a basis for the evolving relationship between the parties. For today's event, Dr. Sassoon will first give a more detailed introduction on the TCA. We will then open up for the panel for discussions on some of the main features of the TCA. We have reserved some time for questions at the end, and I may ask you to use the Q&A function to ask for the questions to the panelists, and we will reserve some time at the end. And Dr. Baltak will also conclude the event. Many thanks to all for participating and welcome. And now over to Dr. Sassoon for her introduction. Thank you very much.
Thank you very much, Chiara, for this very kind introduction. So I wanted to just give a brief introduction of the TCA, looking at the provision on applicable law, which always has been my passion, if you can call it that way. So the TCA is one of the two international agreements that are regulating the UK-EU relationship after Brexit. The first is the withdrawal agreement, and then the second is the TCA that entered into force only at the beginning of this year. There are some substantive provision, and this is the first part of the agreement. Several provision concerning investors. There is a definition of investors, which is a quite detailed definition of investment, which would exclude, at least on its face, the idea of postal box companies. So they have to have they have to be investors and have to have a substantive link in connection with the country where they're incorporated. The substantive provision here briefly, they just provide for the guarantee of non-discrimination. There is a most favored nation treatment. There is a provision on denial of benefits. What is missing is definitely missing fair and equitable treatment is not there. But otherwise, I mean, there is a general guarantee of non-discrimination and of treatment, equal treatment between companies from third countries and from the parties to the TCA. Now, although there is a substantive protection, there is no investor state enforcement mechanism. So what any breach or violation of this substantive provision would have to be raised by the state and would as a settlement of dispute between states, so something analogous to the WTO mechanism. Why this is not there is, of course, a question that we are not going to discuss in this setting. It's just we have to acknowledge that there is all this substantive provision on one hand, and on the other hand, the mechanism to enforce them is a mechanism which leaves to the state, so the European Union on one hand, or the United Kingdom on the other, the ability to issue and commence proceedings. What I wanted to do in this setting, since I have just a couple of minutes, is to look at the provision on applicable law. So what is the law applicable? How would we interpret this trade and cooperation agreement? Article Comprov 13 indicates that the agreement, the TCA, and also the supplementing agreement, because it seems that the trade and cooperation agreement is the first, but they might be, as we will discuss later, it is probably some sort of umbrella agreement, but there will be other supplementing agreement. So the TCA for now shall be interpreted in good faith, in accordance with their ordinary meaning and in context and in light of the object and purpose of the agreements, in accordance with customary rules of interpretation of public international law. So what do we have here? We have an indication that you have to interpret this agreement in good faith. And there is also a provision on good faith, which seems interesting because the idea is that the parties, and I read the provision on good faith, which is Article Comprov 3, the parties shall, in full mutual respect and good faith, assist each other in carrying out tasks that flow from this agreement and any supplementing agreement. So what we have here here is very much a good faith on one hand, which is again something very undefined, and customary international law as far as the interpretation of the agreement is concerned. The article Comprov 13 states clearly that the agreement does not establish an obligation to interpret the provision in accordance with domestic law of either party. So domestic law should be kept out of the interpretation of the agreement. Of course, the first question that comes to everybody is how can you assess if there is a violation of a national treatment without looking at the domestic law of the place where there is such a violation. So it's as the TCA lives in a sort of in his own atmosphere, in his own hemisphere. The other provision, general provision, very important, is about private rights, and is Article Comprov 16, where it says that nothing in this agreement or any supplementing agreement shall be construed as conferring rights or imposing obligation in persons other than those created between the parties, which means, if you read it as it seems in looking at taking into account the ordinary meaning, that private investor, that this agreement does not confer rights or obligation on investors. However, the article, the paragraph before, it says that the interpretation of this agreement is not binding on the courts of either party. So now the question again is if the court of either party can say something on the agreement, on what are they going to opine? If the parties have to refer the dispute to the settlement agreement provided in there, and if investors do not have any rights. So again, these are questions, I guess, to be discussed in the future. As far as the applicable law, and on this, I mean, this is the last point I wanted to make on this, on what is the task of the tribunals and what is the applicable law that the tribunals will use. So in this case, will apply. So in this case, the tribunal will refer to the application of the TSA in accordance with good faith. They will invoke public international law, but they have no jurisdiction to determine the legality of any measure in accordance with the domestic law of a party. So here it is clear that the TCA is an agreement that will have to be interpreted as an agreement by itself. So it has to be enforced and in good faith by both sides, so by the European Union and by the UK. The tribunal will have to look only at the rules of international law, and here there is no equivalent provision about the European law. In fact, in the withdrawal agreement, it says clearly that the arbitration set up under the withdrawal agreement, the arbitrators will have, there is a reference mechanism, so there can be invoked the application of European law, but in this case, it has to be interpreted by the Court of European Justice. With the TCA, there was a conscious decision of exclude the application of European law in general, and so the arbitrators will have to look at international law without any reference, specific reference to domestic law. Now, having given this very brief introduction, having looked at the law applicable in this context, I would like to ask Professor Mistelis as to the legal nature of the TCA and how would you interpret this?
Thank you, Monique. You don't give me an easy task. I think the whole challenge with a particular topic is that it is, in some respects, evolving, and it's interesting that the operation of the TCA has been on a provisional basis. The ratification discussion is taking place today. Looking at the legal nature of the TCA, perhaps one point that we could make is that there are various models of bilateral cooperation, even if on one side there's a regional economic integration organization such as the European Union. And what we have normally, the historical sort of early lighter level of cooperation is a BIT, in the sense that a BIT does not require much of an integration of the economic relationship of the parties, no trade sort of arrangements. And historically, BITs were the treaties that states will be signing as a matter of a visit of a minister. And of course, the consequences were unfolded through the explosion of ISDS in the later part of the 20th century. So the balance, of course, in BITs, and became a hallmark of the BITs, is to have an investor-state dispute settlement mechanism, which in most circumstances would amount to an investor-state arbitration. Of course, if the relationship are closer, then a BIT would not do what is necessary for the economic relationships to blossom further. And then what one would do is a free trade agreement. And the US, very much based on the model of NAFTA, has created a number of free trade agreements with Colombia, with Singapore, with so many other countries. And of course, the characteristic of the FTAs is that they would typically have also an investment protection chapter. And effectively, private parties might have a number of different ways to resort to investment arbitration, perhaps less so to investor mediation. And FTAs will also have quite detailed rules of procedure. One of the main contributions that FTAs have made to investment dispute settlement is sort of the call for transparency. A lot of them operate on public hearings with full transparency, access of non-disputing parties to the hearing, and so on. Now, the TCA, and perhaps it's not my words, but that's Michel Barnier's words, the EU main negotiator of the TCA, is that effectively is a divorce settlement, is a divorce agreement. And of course, while a BIT or any arbitration clause, any ISDS clause is a prenuptial, you're very enthusiastic with your partner, but you want to have an exit strategy if something goes wrong. The TCA is, all of it is an exit strategy. But it's an exit strategy with a G5 state, the fifth largest economy in the world, that is still the UK, and on the other side, a very, very important politically and economic organization. And perhaps I should say, for the avoidance of doubt, I've never been a Brexit supporter, and I have benefited from European integration significantly. As you could understand from my CV, I have been able to exercise mobility and study in various European countries. But the TCA as a divorce settlement is effectively a way of containing perhaps the dispute, so that the kids, or whatever the equivalent of the kids would be in that scenario, would not suffer too much. And it's very interesting that Boris Johnson states in the foreword that the UK is, of course, culturally, spiritually, and emotionally part of Europe. And the agreement provides for close and friendly cooperation with our neighbors. So the focus is therefore on trade. So and doesn't have any investment chapter. In that sense, it's not a typical FTA. It does have some dispute settlement, but I would attempt to say that the TCA is a sui generis or a sui juris free trade agreement covering the EU-UK cooperation on certain matters, including economic, social, environmental, fisheries. It has also citizen security, and also has a governance framework. It's important that there's a level playing field for trade purposes. As part of that, there are a number of oversight bodies and of course an arbitration tribunal that will operate on a state-to-state basis. So it's interesting enough that the TCA builds up on WTO, as well as the UK and EU FTA with Japan. And in so many ways is innovative and is ambitious, but as any divorce settlement has a lot of baggage. So is a compromise, and is what, sort of, to paraphrase pop culture, sort of Gwyneth Paltrow, is a conscious uncoupling document. So that effectively meant that negotiations had particular sort of limitations And that perhaps is reflected in the document, which doesn't go as far or as one would have liked. There's very little on services. A lot of these topics are to be discussed. However, it seems today that the European Parliament, both the Foreign Affairs Committee and the Trade Committee, that perhaps the two most powerful committees of the European Parliament, are making positive recommendations. And interestingly enough, both of them are led by German MEPs.
Thank you very much, Lucas. So, Professor Daly, do you have any more comments on this divorce compromise that is the TCA?
Thank you, Monique. Yes, actually, Lucas presented a very exhaustive overview on the legal nature, but I just want to make two points. And the first one is very, very general. And in order to introduce this point, I will take the metaphor which was presented by Lucas of the divorce and the divorce agreement. And the impression I had reading the TCA is that, especially considering the role of international law, is that one of the parties wants to very enthusiastic of the new partner is really wants to emphasize the new situation and take a distance from the former partner, so that we have even in the preamble of the TCA, we have stressed that the United Kingdom is an independent coastal state with corresponding rights and obligations under international law. And then, as you already mentioned, the principles of interpretations and in definitions refer to public international law. So the role of the international law, customary rules of public international law, and the role of the Vienna Convention on the Law of Treaties is extremely important. So this one is my first point. It is clearly that this is not a treaty within the wider ambit of EU law, but it's a creature of pure international law. So it goes under the big umbrella of public international law. And here comes my second point, which is connected to this one, because it refers to the human rights conditionality in the TCA as a whole. And the starting point for human rights conditionality of the TCA is in the common provisions of the TCA. In the section, first we have in the preamble, the parties reaffirm their commitment to democratic principles, rule of law, and to human rights. And then the human rights are recorded again in a section which is devoted to the basis for cooperation, where we find the article Comprof 12 with essential elements, among which, together with democracy, rule of law, we find again human rights. And so the role of human rights, in particular, respect for human rights, which as it's stated, which underpin the domestic international policies, and parties reaffirm their respect for the Universal Declaration of Human Rights. There is no reference to the European Convention on Human Rights. It's not mentioned specifically, although it is, of course, on one of the international human rights treaties which the UK is particularly connected to. So the consequence of defining these human rights as an essential element of the TCA is that it goes again in the Title 3 of the Part 6, because a serious or substantial failure by one of the parties to fulfill the obligations which are described as essential elements, and within that human rights, protection of human rights, might have the effect to terminate or suspend the operation of this agreement. So I wanted just to stress this point, because I think it's quite interesting to see how we find a lot of international law in the treaty, but it seems sometimes that it's made on purpose in order to stress the distance with the EU law, and therefore also with the with the law of the EU members.
Thank you very much, Maria Beatrice and Lucas, for the introduction on the legal nature of the TCA. And of course, I'm sure that we'll have some additional thoughts after we discuss four points, I would say, in the next minutes or so. So probably we'll want to add some additional comments to the legal nature of the TCA. But to start with, I suggest we focus first on something that Monique has mentioned, which is the TCA does not contain an investment dispute resolution mechanism, but only a mechanism analogous to WTO. And I dare to add to this also, one could also consider one of the provisions of the TCA article serving 2.4.4, which relates basically the idea of an IDS settlement mechanism with the issue of the importation for the MFN mechanism. So perhaps we start from this, and I would ask Katarina if she would like to commence on this. What are your thoughts of not having this ISDS mechanism in the TCA? What are the consequences in your opinion?
Thank you very much, Karina. The decision must be put in perspective. I think there are two ways of interpreting the decision not to include investor-state dispute settlement. The first is that it is evidence of the uncomfortable relationship between the EU and the UK, the divorce settlement that Lucas mentioned. And the second one is to see it as a policy shift. So we know the EU policy on investor-state dispute settlement. We know it because the EU has been vocal about it, has published the relevant documents. It pursues the policy, notably with respect to the Multilateral Investment Court in the Antitrust Working Group 3 negotiations. But we don't yet necessarily know the UK's policy with respect to investor-state dispute settlement. So at least if we take the Antitrust Working Group 3 context, as far as I know, the United Kingdom has not yet made a submission to show where it stands concerning investor-state dispute settlement. That said, the United Kingdom has not signed a traditional bilateral investment treaty since 2010. I mean, there may be reasons for that, and the first reason that comes to mind is that already the United Kingdom has many bilateral investment treaties, so it doesn't necessarily need a new investment treaties. I would like to point out at the same time that, at least according to UNCTAD data, between 2019 and 2020, so over the period of 2 years, the United Kingdom has signed 26 agreements with investment provisions. So not bilateral investment treaties, but other treaties that have some provisions on investment. And one of them is, of course, the TCA. So these agreements, these other new agreements that the United Kingdom has been signing are new agreements that do not include investor-state dispute settlement, but, and it is an important but, many of them coexist with traditional bilateral investment treaties. So if in the FTA, the United Kingdom does not include investor-state dispute settlement, if it has in parallel a bilateral investment treaty where it does include investor-state dispute settlement, then I mean, it doesn't matter that the FTA does not include investor-state dispute settlement. When it comes to the TCA, and I'll stop here on the treaties of the United Kingdom, because we're going to hear later about them. The lowest common denominator seems to have prevailed when it came to the TCA. So since the parties could not agree on including investor-state dispute settlement, the solution was not to include investor-state dispute settlement. So my assumption here is that, again, it was the United Kingdom that didn't want investor-state dispute settlement, since the EU seems to want investor-state dispute settlement. Now, what it means in practice. So from an economic union, essentially we fall back to less than a state-of-the-art FTA. Of course, you might say, what is a state-of-the-art FTA? I mean, I would argue that a state-of-the-art FTA would include investor-state dispute settlement. So is there on the part of the United Kingdom a desire to treat the EU just like any other partner, to sort of show that there is no special relationship between the UK and the EU? As Monique pointed out at the beginning, there are a few substantive standards in the treaty, and there is no manner of effectively enforcing them, other than in state-state proceedings, in state-state arbitration. Domestic courts have no jurisdiction to resolve disputes under the TCA. You might say this is normal. Decisions of the state-to-state arbitration tribunal are not binding on domestic courts. There is this desire to delimit very clearly the international level, so what the state-state arbitral tribunal can do and the domestic level. Decisions of, I think this is something we had as well, but I'll underline it, decisions of the state-state arbitral tribunal cannot add to or diminish the rights and obligations of the parties under the agreement. The arbitral tribunal, again, the state-state arbitral tribunal has no jurisdiction to determine the legality of a measure alleged to be a breach of the agreement under the domestic law of a party. To some extent, some of these provisions are understandable, and we could imagine that they would be there because of the relevant decisions of the Court of Justice of the European Union that might have made otherwise the agreement incompatible with EU law. So I'm not so much surprised about this desire to separate the two levels. However, what I do find surprising and disappointing is that the treaty does not have investor-state dispute settlement. So in a field where investor-state dispute settlement has been an option and has been the norm, there is a clear willingness to remove the means by which disputes can be resolved. And I would say there's even a more worrying aspect. In reality, investors are only indirectly concerned since the rights granted by the TCA remain interstate rights. Investors don't acquire any direct, albeit limited rights. The rights that the TCA grants are interstate rights. I'm concerned that the fact that there is no investor-state dispute settlement reveals an ahistorical view of why investor-state arbitration was included in the first place in investment treaties. There was this desire to depoliticize disputes, to avoid gunboat diplomacy. Well, you might say there's no risk of gunboat diplomacy between the EU and the UK. However, to the extent that the same type of agreement would be used multilaterally, in the sense that we may imagine that other treaties would have the same form, there may be other occasions, relations with other states where this might be an issue. I believe in multilateralism, in having a uniform solution for everyone, so I'm very skeptical about this. I will end with two final comments, and the one is, what is the likely impact on ISDS reform? Well, maybe or probably more fragmentation, but, and this is my final comment, is this really the last word on investment protection in EU-UK relations? Will other agreements not be signed? So will we not have in the future bilateral investment treaties that might eventually do what bilateral investment treaties usually do, and include investor-state dispute settlement? Obviously, it is a question. I don't have the answer to that, but I was trying to find a positive note on which to close. Thank you very much.
Thank you, Catherine. I'm sure that there are some follow-up comments from our panelists. Perhaps one follow-up question, because ISDS reform was mentioned, is what is the position of UK in the working group 3, if there is such position, and how would that match the EU's position as well, and probably EU's position with respect to other FTAs. And the comment that was made by Catherine was very important. Any follow-up agreements there might be, for example, like EU-China's framework, that we're expecting something like this in the next years.
If I may make a comment, I agree entirely with Catherine that there is a distinct and deliberate policy shift towards not including ISDS at this stage in these agreements. And I think whether one likes it or not, that's perhaps academic, because effectively we have a situation where, as often is repeated in the Untitled Working Group 3, this is a state-led process. Now, the reason why the UK has not had BITs since 2010 is that actually the UK has played by the book, and therefore, ever since the European Commission has taken control of investment policy, the UK decided to reduce the treaty office in the Foreign Commonwealth Office significantly, and give part of this work to the Department of Trade, the Department of International Trade, contrary to, for example, to Germany or Austria that have been signing BITs after 2010. So there is a vacuum, and I think the policy is being formulated because the priority seems to be trade. And I think for the UK, the main consideration at this stage was services, and particularly financial services. Legal services perhaps have got in the end a rather favorable sort of matter, but we don't have gunboat diplomacy. But the French Europe minister threatens with reprisals in financial services. We were never going to give you access to financial services. There will not be gunboats because the UK is one of the most important net contributors to NATO, and together with all of the other European states. But some of this rhetoric is almost as good as gunboat diplomacy.
Then probably an organic question that would be, and if there are any immediate thoughts on this, otherwise we can save it for later, is the fact that no EU member state have signed or participated in the TCA, which normally happens with the EU FTAs, is a clear sign that there was absolutely no intention of putting this at the level of investors. As we know, usually the EU and EU member states share their competences with respect to investments, and therefore the TCA cannot be interpreted as contemplating anything with respect to investors. And as Catherine was mentioning, everything stays at the level of state rights and obligations. And maybe this is a good way to move to Maria Beatrice and ask the follow-up question, which, because we don't have this investor rights and obligations, well, mostly rights and obligation, obviously, whether the current UK-EU member state bilateral investment treaties are still applicable, and investors can rely as an escape door in the context of the TCA. I know it's a complex question, in particular in the light of the intra-EU termination agreement, and I think Maria Beatrice will also address that to some extent. So I'll give the floor to you, Maria Beatrice.
Thank you, Karina. Yes, this is a very difficult question, and it's me who needs an escape door in answering this question. Well, of course, I think the starting point is the limited investment protection under the TCA. So we have already had with Catherine the description of the lack of proper investor-state dispute mechanism. We know that the TCA provides only limited protection. Monique also gave us some hints. And this, of course, gives rise to considerable uncertainty and potential risks for investors. The provisions which are applicable to foreign investments are on the Part 2 and trade, transport, fisheries, and other arrangements, and heading 1, Title 2. So the provisions which are contained in the TCA also, I think, differ considerably from provisions which are commonly found in other free trade agreements, and also Lucas mentioned some of these. But the point which goes to the question you asked me is that there is no mention in the TCA of the BITs with the UK, which are still in force with some EU states. So the question is, what is the future of these agreements? I said there is no notice, no mention, no notice of termination of any of the 11 BITs which are still in force between the UK and the EU member states. So we are dealing with these 11 BITs with agreements, treaties concluded with states that at the time of signature were not EU members. So this is a very gray area where it is therefore necessary to try to understand what will happen. Which are the BITs under consideration? I said 11 treaties signed in the period 1986-1997 by those countries prior to their accession to the EU. In fact, we have the BITs with Bulgaria, Czech Republic, Croatia, Estonia, Hungary, Latvia, Lithuania, Malta, Romania, Slovakia, and Slovenia. There is still another BIT which was signed by the UK with Poland in 1986 or 87, which was terminated by Poland in 2019. But we all know that there is a 15-year-long sunset clause. Therefore, it will remain in effect for all investments made while it was still in force until 2035. So no mention of existing UK BITs with EU member states. Still, the TCA expressly provides that the agreement applies without prejudice to any earlier bilateral agreement between the UK and the EU member states, and the parties reaffirm their obligations to implement any such agreement. Moreover, the TCA acknowledges the possibility that UK and EU member states may conclude other bilateral agreements between them, and possibly this is the end of what Catherine introduced. Such agreements will constitute, as they call them, supporting agreements to the TCA, so forming an integral part of the bilateral relations. But what is the position of UK towards the intra-EU BITs? We know that in January 2019, further to the ACMEA decision, the UK was aligned with the other 27 states and signed the declaration of the member states of the legal consequence of the ACMEA judgment. But in May 2020, only 23 EU states signed the plurilateral treaty, the agreement to terminate the treaties, and the UK was not among them. The decision not to sign the agreement determined, as we know, a reaction by the European Commission, which as a consequence launched infringement proceedings against UK and Finland. And in the recent opinions, the Commission regrets that the United Kingdom did not sign the treaty and urges the United Kingdom to take all necessary actions to remove the BITs with EU member states from its legal orders. And the Commission recalls the fact that under the EU-UK withdrawal agreement, the United Kingdom was bound by union law during the transition period. And so therefore the Commission was competent to launch an infringement procedure. So the effects of the recent opinion by the EC Commission inevitably raised the question, which future for the BITs? So the status of the BITs remain in an area of uncertainty. Certainly Brexit changed the perspective, because before Brexit, the ISDS provision of this BIT may be found to be incompatible with EU law, but now the EU law no longer binds the UK. And so the BITs with EU member states have effectively become extra EU BITs. So as a consequence of this, can we assume that they remain in force, or that's the other possibility raised by some commentators, are the BITs automatically terminated under Article 59 of the Vienna Convention of Law Treaties? Can the TCA consider use supervenience? Oh no, that's a question. So we know that the Vienna Convention has been variously applied in investment law in relation to successive treaties relating to the same subject matter, and so referring to Article 30. In the present case, we have two treaties, and parties to each treaty only partially coincide. So the issue of the effects of subsequent treaties addressing partly the same subject matter is dealt with the Vienna Convention under Article 59, paragraph 1. And we know that the treaty shall be considered terminated if all the parties to it related to the same subject matter. But are we dealing with the same subject matter? TCA and the BIT. Moreover, paragraph 1, letter A. The possibility is also that the parties have intended that the matter should be governed by the treaty. This is not the case. Or the treaty will be considered terminated, this is still Article 59, if incompatible with those of the earlier one. Are the provisions incompatible in the intentions of the party of the TCA? It seems that there is no incompatibility, at least under the expression of the TCA, which says without prejudice of any earlier bilateral agreement. So in conclusion, in order for Article 59 to apply and therefore automatically terminate the BATs, the successive treaties must relate to the same subject matter and be incompatible. So the BAT have some commonality with the principles expressed in the TCA, but in my opinion, it might be really a stretch to conclude that the treaties have the same subject matter. We also said that priority was trade. And also because even having the same subject matter, I think the normative purpose of the treaties considered could be absolutely diverging. So the idea is that there is no automatic termination according to Article 59. So what happens now? So they remain in force, but in case a dispute arises and the case ends up in front of the Court of Justice, and the court will find the provisions, the ISDS provision of these BATs no more compatible with EU law. So what will happen? And of course, we know that the UK considers EU law no more binding. And so the principles expressed in ACMEA are irrelevant for the UK. The UK is insulated from the ACMEA principles. So on the one hand, we cannot consider that impossible that the Commission will continue its campaign and pursue the infringement proceedings all the way to the Court of Justice. But then in this case, it would be difficult to, I think, to predict the outcome. We have some months ahead. I'm not aware of any new development in these recent days. And in that case, the judgment that could be rendered by the Court of Justice against the UK could be considered a Pyrrhic victory for the EU, but it could also have adverse effects on the investors. And what about investors now? Because that's my last point, and then I conclude. So we know that there are limited substantive protection in the TCA and a lack of mechanism for the investors to seek relief. So the idea of many commentators is that, and I think I cannot but share the same opinion, that investors might be considerably better off relying where applicable on one of the existing BATs between the UK and the EU members. But still there is another opportunity, which is the possibility that one or more of the 12 member states, which are still UK, EU BATs, could decide to terminate the BAT unilaterally. So maybe it's still too early to reach a conclusion. So my impression is that the treaties will remain in force and have to be considered extra EU BATs. But still the possibility of a brand new investment protection regime and additional agreement remains, and maybe it's a conclusion, optimistic conclusion also on my side.
Many thanks, Maria Beatrice. This was a very complex question, and we really thank you for highlighting some of the complexities and what should be expected. And I'm grateful for your final kind of positive nature. But it's interesting to see what's going to happen really in the next few months. May I ask, are there comments from the other panelists? Would anybody like to comment on Maria Beatrice's view of the complexity and the future, or on any other points that she raised? And when you think, may I also remind the attendees to the webinar that the Q&A function, the button on the bottom right corner of your screen is now active, and I urge you to please ask questions to our panelists for this very interesting on this very interesting topic. There's really so many issues of public international law and European Union law, and what is the future of the relationship? What has left? How is Brexit kind of changing all of our understanding of investment law and dispute resolution clauses? We have discussed, and several panelists have already mentioned some of the UK past behavior. We said that during the wedding, during the marriage, the UK was actually very faithful and didn't really go outside looking for new BITs. But now, to continue with Lucas's metaphor, the UK is a new single bloke. He's a new member. Is a single member now, and is looking for new relationship. We also have in the past, we know, and since 2019, actually, the UK has been looking around and signed 26 agreements so far, and has signed free trade agreement and several BITs. Lucas, what do these past BITs and new free trade agreement that the UK has signed tell us possibly of the UK future behavior? What do you think the UK investment policy will be going forward? And what will these agreements grant? How do, especially on the issue of the dispute, investment dispute rules and protections, what have the past taught us, and how should we look at the future and focusing really very much on the UK, on what we should expect from the UK?
Perhaps I should add with a comment to Maria Beatrice's very sort of comprehensive review of the state of affairs from a public international perspective, but also with a disclaimer. The disclaimer is that there's no document in the public domain that somehow sets out the UK post-Brexit policy in respect of investment protection and ISDS. And I think the point that Catherine has already made about sort of the policy shift perhaps is an ongoing issue. The note I want to make about what Maria Beatrice said is, of course, it's not just the BITs, but we also have the Energy Charter Treaty. And one of the things I have been looking is that the UK investors have been involved in 87 cases. That amounts to roughly 10% I mean, the UK has always had many BITs, but it's perhaps 9% of the investment disputes that we know, let's say 10%. Out of these 87 cases, 16 or 17 arise out of the Energy Charter Treaty. So the Energy Charter Treaty is 20% of the UK sort of output in terms of UK investor claims. And collectively, the respondents states are about 30 or 31 respondent states. So it's a very broad matter. And if one, and the majority, of course, are non-EU member states. I also, of course, looked at in the public domain, we have one clear BIT case against the UK that we have not much data on the basis of the India UK BIT. And of course, the MOX plant case has a number of investment dimensions as well. That's again, not much to say. Now, this is not, the numbers are reasonable and the cases have gone different ways. Given that we move more towards trade agreements, trade disputes, I also looked at what happened in terms of the UK and the WTO. And under the WTO, the UK has been responded in 3 cases. So perhaps more often than in the under BIT system. And the UK has been a third party in 5 cases. So from a UK perspective, the WTO perhaps, or the WTO type agreements raise a slightly higher threat. And there's already a question in the Q&A about sort of the vaccine trade war between the EU and the UK, although of course AstraZeneca is an Anglo-Swedish company, and a lot of the Pfizer-BioNTech, which is an American, German, Turkish company, a lot of the components come from the UK or other parts of the world. So yes, the UK has no clear policy, and I think out of the sort of the 91 BITs which are in force and the 27 agreements of which only free trade agreements of only which is in force, the ECT. So if one were trying to see from the text what is the post-Brexit position, perhaps one can look at the UK-Japan Comprehensive Economic Partnership Agreement, and of course Article 843 has a review clause. There could be a committee composed of representatives that includes sort of officials from relevant ministries or agencies to look at the matters and may invite other parties. And of course, in Chapter 22, there's the state-to-state dispute, there's mediation, there's consultation, rather request for information, consultation, mediation, establishment of panel and arbitration. But of course, what one should point out here is that Japan and UK are both G7 states. They have a very similar levels of economic development. And if one were to still keep the traditional Salini definition of investment, it would be almost impossible to have a significant contribution to the economic development of either the UK or the Japan if a Japanese company builds a power plant in the UK, or if a UK company has a sort of a fintech facility in Japan. And similar, the other texts which are relevant, of course, is the UK-Canada TCA. Well, of course, there we have investment protections and ISDS retained, but the ISDS is very much shaped in the EU investment court system, and is suspended for 3 years and subject to and made subject to a comprehensive review. And then, of course, we have also the UK, Vietnam, and the UK Singapore continuity agreements, where, of course, the UK extends the EU FTAs, their transition, but not to the EU investment protection agreements that were part of that. And of course, there are interesting trade negotiations, including with Australia, New Zealand, and the US. The US Trade Secretary was on the news on Saturday on a large interview, sort of advocating the importance of the Australia deal. And of course, a lot of the government's position is that you should not just look at the trade numbers now, you should look at what the trade numbers can be, sort of exporting whiskey, exporting British cars, and so on. So not the current formula that will not be appropriate. But of course, for me, the most important policy direction for the UK post-Brexit position is the UK's application in January to join CPTPP. And I think that is a very, very, very important development, because TPP politically and economically is perhaps the silver lining in so many ways. We spoke about optimism, but CPTPP in the Pacific Rim region, with states of different levels of development and a number of significant emerging markets, is bringing some sort of an element of hope, and also has very interesting provisions in the text about conflict of treaties, perhaps the most comprehensive set of provisions on conflict of treaties and priorities to be given between them. So everything that brings higher level of protection will prevail, and that's actually very, very, very important. So it seems to me that the UK has taken a rather cautious and incremental approach, and the policy, of course, is adapted depending on the peculiarities of the relationship and the negotiating partner. And at this stage, it seems to me that the UK government takes a position that there's no politics in trade, while there's politics in investment protection. And since there's no politics in trade, we run with sort of bearing the flag of trade, and investment is something that could follow as and when things change, and if things change. And since sort of the focus has been on trade rather than investment, I think the UK will continue to, as a matter of governmental policy, as a matter of what the City UK says, which perhaps is sort of, for those who are not very familiar with the country, the lobby of the City of London to promote the British economy. It used to be called many years, 25 years back, British Invisible. So it's economic diplomacy of the UK. I think they will favor arbitration and ISDS, but perhaps in the interim, they will be focusing very much on contract-based arbitration. And I think the traditional legal advice that has been provided to business will be continued to be that you have to negotiate dispute resolution clauses and contract-based arbitration. There's something which is technically also consistent with the findings of the Queen Mary and CCIAG survey about investors' preference about ISDS reforms, is if it happens, it's okay. If it doesn't happen, what we do care about is a contract-based arbitration. And I think that perhaps is the position of the UK government at this stage.
Many thanks, Lucas. I'm grateful that we're all trying to look at the silver lining and kind of the positive issues. And I think you really highlighted a lot of interesting issues, and especially this idea of looking at the CPTPP and how important actually that CPTPP has been, a kind of revolutionary. And I wonder now, speaking from DC today, what will the Biden administration do on that issue too? But interesting thinking about trade and the focus on trade and how there's so many different formats and very complex treaties, and looking how kind of the conflicts of treaties and how that works. So thank you very much. Eric, did you have a comment that you would like to share?
Yes, thank you. Well, first of all, I think Lucas explained very well what can be expected. But the point I wanted to make is that we have a bit of a tendency to link by definition trade and investment, because in recent years we have seen a lot of free trade agreements with investment chapters. But I mean, historically also, and typically they are nonetheless have grown as relatively distinct treaties. So maybe, and again, it's very difficult to know this for sure. The UK might have, first of all, an interest in expanding access to markets and trade more than protecting its foreigners who invest abroad at this precise moment in time. Also, maybe, and this perhaps is also a reason why investment is so absent from the TCA, is that it maybe, again, their focus was not necessarily on seeking protection of UK investments in the UK and vice versa, right? So I think it's also a question of priority that plays a role. And I can well imagine, as Lucas explained, that priorities now lie more in signing trade agreements to replace a bit the network that there was before, and to gain access to markets, which is probably very important for the UK, and hence investment may follow or not, you don't know. But I think it's important to distinguish clearly and not have this, what we might think now is, if we have trade, we need investment, and vice versa. You can uncouple both, and they have been uncoupled for many years. And so I find it not necessarily surprising that there's a focus now on trade and not necessarily on investment. Indeed, it can follow. So that's the main point I wanted to make.
Many thanks, Eric. This is actually quite interesting, thinking about, of course, when a state acts, he has so many different interests that one has to think about, and it's interesting to see how all of that works in the policy perspective. If there are no other comments on this question, I'd like to change the focus a little bit before opening to the Q&A.
I have a comment, actually.
Yes, absolutely, Lucas, go ahead.
I think very much following on what Eric was saying, I think for many people, investment law is a subordinate to international economic law, and I think that's perhaps a wrong perception. And I see books being published on that very theme, that investment law is part of economic law. And I think economic law, in a more traditional sense, developed around the practice of GATT and WTO, while economic law was perhaps a more classical public international law, because it was less regulatory and more sort of libertarian, if you wish. So I think where we have one of the synergy, and I think which is the elephant in the room, if you wish, is the ECT, because the Untitled Chapter Treaty has both trade and investment, and accounts for a very large number of cases at the moment. And there's a process of modernization, in inverted commas, perhaps, of the ECT, where of course there's a head-on collision between various interests. And I have not been following the process very closely, but I think as a multilateral treaty, as the Untitled Chapter Treaty is, and having received criticism from various sources, the Russian Federation, for example, a few years back, now from the EU, from within the EU, because of the number of the renewable energy cases. I think that's why I'm saying that investment perhaps has a bit more ideology in the end, because of this libertarian approach, than trade.
Thank you. That was very interesting. Now, I'd like to shift a little bit to another issue that is very much at the forefront of our thinking about investment and, in general, dispute resolution mechanisms. The UK has recently published an expression of interest in relation to the UK list of arbitrators for the TCA. And one of the requirements is for prospective arbitrators to comply with the Code of Conduct for Arbitrators, which is annexed to the TCA. 2 days ago, I think, or maybe a little more, but UNCITRAL and ICSID issued the second draft of the Code of Conduct for Adjudicators for consideration for Working Group 3 of UNCITRAL. And now there is very much a renewed interest in ethics, and who are the arbitrators, what are the ethics, the rules that apply to arbitrators. And of course, we mentioned the CPTPP, and that is very much ethics of arbitrators is very much at the forefront in that agreement too. Eric, may I ask you, what do you see? Do you see any similarities between what we find in the Code of Conduct for the TCA, the draft Code of Conduct for the ICSID, UNCITRAL? Do you think some of the issues are addressed in a different way, or what do you think? What do you think in general about this interest for ethics, but more specifically on these two codes? How do they compare?
Thanks, Chiara. Yes, well, I think the first question is, can you compare them, or should you compare it to something else? And this relates to the very nature of the TCA, which we have discussed. So how do you perceive the TCA? I tend to agree with what has been said before. It's a very sui generis agreement. I mean, it's really, there's trade aspects, there's some investment provisions in there, there are many other provisions in there. So it's really a divorce agreement, as Lucas explained. And the question then is always, how can you, or to what can you compare it? So that's a first question. The dispute settlement provisions are really very different also of what you find, and we've discussed it in several minutes ago. So the functions of the tribunal, terms of reference, really are very, very similar to what you find in WTO law. The rules on appointment are also very different, which you find in the TCA and in the annex. The requirements are also quite different than the usual. You have a bit of a copy-paste of Article 2 of the ICJ statute, quite interestingly, on the qualifications required for appointment in the highest judicial offices, etc. So I think, first of all, the requirements are a bit different. The rules of procedure, also in terms of replacement, are relatively different. So you actually, in the rules, in the annex, the rules of procedure, you actually have the possibility, in case of a problem of independence and impartiality, that the arbitrator can ameliorate the failure, which is quite interesting. Huh? So you can actually detect the failure and then say to the arbitrator, well, is there something you can do about it? Which is, again, relatively different. So then the question is, how do you compare both sets? This is here state to state dispute settlement. So the arbitrators are appointed for this particular treaty. So I think it's a very different scope of the Code of Conduct that ICSID UNCITRAL is developing, which is really a Code of Conduct intended to regulate an entire sector, that is investor-state arbitration. So here we have a Code of Conduct only for the treaty and for interstate. The interesting thing is the Code of Conduct is in terms of, if you compare to other state-to-state arbitration, relatively more strict. There's a famous decision on the challenge of Judge Greenwood in the Chagos arbitration, where the tribunal basically said, well, under the law of the Sea Convention, we don't see any reason to treat independence and impartiality requirements of arbitrators any more strict than we would for judges. So they basically said the appearance of bias test doesn't apply. So here, nonetheless, you have a bit of an equation with the standards applicable in investor-state arbitration to those applicable in this specific context, which I find, first of all, a very interesting point. If you look at the specific rules, I think there bear a lot of similarities. I mean, you have, of course, slight deviances, you have slight reformulations, slight different emphasis. But I think all in all, they reflect relatively similar ideas. There's for instance, to point out some small differences on the role of, or the obligation, of former arbitrators. The Annex TCA is slightly more clear or more explicit on the fact that, and it's a quite interesting provision in itself, which says that each former arbitrator shall avoid actions that may create the appearance that he or she was biased in carrying out the duties, which I find quite interesting to see how it evolves, how it would apply in practice. So these are questions that are not really in the code of conduct of the ICSID. So there are, again, small deviances, but I think the gist and the main principles are relatively similar. So one question I also asked myself was why not simply incorporate the code of conduct? So this would have been quite interesting. Now, first of all, it's of course a draft still. So can you incorporate a draft still subject to change? Maybe. But then you need, of course, to agree on the draft and on the future to be adopted draft. So that might have been a problem. Another option might have been to refer to existing codes, the ITA guidelines, but the very fact that ICSID and UNSCO are negotiating a new code of conduct maybe indicates that there was a need, or at least a perceived need, to have new rules on this, and then reference to the existing rules and norms, the ITA guidelines, might not have been interesting. The ITA guidelines are also typically not for interstate arbitration. And again, the Chagos tribunal clearly said the ITA guidelines do not apply at all to interstate arbitration, quite interestingly. It's also not the first treaty to adopt its own code of conduct. The Dutch model BIT has a commitment to negotiate a new code of conduct that has also different rules that apply to arbitration, with specific rules on double hatting. So these rules, of course, on double hatting, this is a second important point, are not in the code of conduct. But again, this is very interesting. The TCA, of course, the question of double hatting doesn't apply as such, because it's an arbitration mechanism for one single treaty, right? Although you can imagine that as it will be applied in the future, that various disputes will apply. And then I think the basic principles and the main principle would avoid in any case arbitrators in the list, on the list, actually acting as counsel to some parties on the TCA and then acting as arbitrator in similar disputes. But I think this is captured roughly by the general principles that are contained there. So I find it interesting. It sort of flows, of course, on the existing discussions and criticism on arbitration and the need for strict standards and regulation instead of organic evolution, organic regulation of the question. Yeah, so I think I'll stop here. I said everything I wanted to say. So thanks, Chiara.
Thank you very much, Eric. I just wanted to raise a couple of questions that have been raised so far. So Lucas answered already to the first in part, but I would like to give an opportunity to the other panelists to comment on. So the first question is from Ian Meredith and is about our optimism. And he says that he sees hard to see how new ISDS rights are likely to be on the table in short order in the face of the current tension over the Northern Ireland Protocol and the vaccine supply battle. Of course, everybody knows that on March 15, 2021, the Commission sent a letter of formal notice for breach of the withdrawal agreement. So here we are in another, the other agreement that we have stemming out from Brexit. Lucas' comment on this, of course, me being Italian, I don't see a lot of tension over there, or at least I think that is definitely not as high as to preclude optimism and the idea that there will be more activity in there. But I'd like to hear the panelists. Of course, I mean, for me, the main issue is really what would the investor do from the substantive provision that cannot be enforced under the TCAA. So whether what will happen from out of these rights. So I'm not sure, Lucas, if maybe you want to add more since you already replied to this first question.
I think this is a very difficult question because people who do not live in the UK might not realize that there have been a number of problems in Northern Ireland in recent periods. There have been people in the streets. There's a feeling that there have been a partial negation or sort of moving away from the Good Friday Agreement, which effectively the peace settlement agreement in Northern Ireland. And therefore, this is something that brings emotion. One good thing that perhaps Northern Ireland is something that is an open thorn in this TCA, because the geographical sort of organization of the United Kingdom, with a part of the country with direct borders with an EU member state, and might have a particular problem, and that is an open wound. I think the intention of the Northern Ireland Protocol was to ensure that at least people who live in either sides of the Northern Irish border would not notice a significant difference in the way they were living. But apparently, trade has been affected quite a bit in January and February. Prices have gone up. Supplies of goods have not been as easy as one would have liked. And not because of tariffs, but because of paperwork, because customs had to work in a different fashion. Because technically we have a free trade agreement, but the paperwork that one has to submit in any element of trade is much more complicated. So I'm afraid that this is being used and perhaps exaggerated in some respects, because politically it serves both sides of the argument. But if this is not a matter that is properly addressed, it could become a much more significant problem. And I sincerely hope it won't. But I wouldn't like to say much more than that, because that's generally becoming a rather political issue, and for which I do not really know enough.
Thank you very much, Lucas. I'm not sure if any other of the panelists would like to add something on this 2 point and on the optimism that is still always with us. So then let's go to the other question, which is also very interesting, and it's from Alexia Nefeli-Duma.
On the optimism side, perhaps one should say, while we have seen for about 10, 15 years attempts to completely sort of eliminate ISDS, I think the current negotiations in UNCITRAL, although there seems to be a mandate for reform, and there has been perhaps even an provisional end day of negotiations, 2025, no one knows exactly what's going to happen. And I think that's while at the same time we see sort of in different parts of the world some more desire for investment agreements.
Thank you, Lucas. I agree. I think that we are going from a period of denial, in a sense, so trying to eliminate ISDS, and then the need to have it maybe in a reform version. So let's go then to question number 2 from Alexia Nefeli-Duma, which says that the TCA doesn't include FET and the provisions about expropriation. And so she says whether we could use EU law as a potential tool to remedy the recourse, invoking the principle of supremacy and direct effect. So on this, the first thing is that, of course, there is no FET, but expropriation can maybe be brought in through the European Human Rights Convention, and the fact they carve out on human rights. As to the EU, I have to say that the travaux préparatoires are clear in the sense that under the TCA, EU cannot be invoked because it's very different, the TCA compared to the withdrawal agreement. But I don't want to say anything before. I don't know if Maria Beatrice, you want to say something, and then I see also Lucas who would like to answer to this question.
Well, I think I cannot add much to this, because it's exactly what I thought. The EU law, I think it's not to be taken into consideration for this. So there is a possibility regarding the link I tried to illustrate at the beginning with some human rights protection, and so probably that is the way. But I think maybe Lucas wants to intervene and add something.
My feeling is that I think I don't think it would be possible technically to import ISDS procedures from other agreements on the basis of the TCA. If the TCA has an additional protocol or has a sort of a branch which covers more a bit of an investment, that would be possible. But I think the direction of travel is, even for those who are in favor of ISDS, that FET provisions will be curtailed. They will have much more, it will be much more nuanced, much longer. We'll have much more of this for the avoidance of doubt and for the avoidance of doubt and so on. So I don't think that will be possible. So if one were to rely on ISDS procedures, it will not be via the TCA, but it will be through a sort of still valid BIT, and there are few. But I don't think the TCA can accommodate that importation the way it has been drafted.
Yes, I agree. I think that the real issue there is also this interpretation in good faith of the TCA, which really doesn't give any real indication on what are the rules of law so that are applicable. So Krina, shall I leave the floor to you?
Thank you very much, Monique. Just a few concluding remarks in the last 2 minutes that we have. And of course, the discussion today was about the TCA, but I think we can all agree that was a reasonable excuse to touch upon broader subjects outside the UK and EU investment policy and for example, look at the ethics and in particular with respect to adjudicators and arbitrators, also to the ISDS reform in the context of the UNCITRAL. But also we focused on more specific aspects of TCA. I think we have something to look forward in the future, possibly this sui generis agreement, as Lucas has mentioned, or a divorce settlement or an exit strategy. It's something that it's now at the table and probably replicated in the future. We'll never know. But I think what is important is that the takeaway from this TCA is a creature of international law, and we could hear more about the interaction between EU law, national law, and public international law. Also on the absence of an ISDS dispute resolution mechanism, as Catherine was mentioning, it is indeed probably the evidence of a divorce, but maybe a policy shift. And to some extent, the parties have settled on the lower denominator for this on this occasion. On whether the UK-EU bilateral investment treaties are still, UK-EU member state bilateral investment treaties are still applicable. We heard from Maria Beatrice that there is no reference to BITs in the TCA, and most likely they are not terminated by the virtue of TCA. We could also hear from Lucas the comments that the Energy Charter Treaty is a completely different creature, and the modernization process might bring a different twist at this end. On the future of UK's investment policy, well, we can only predict that. As we could hear, there is no UK official post-Brexit policy, but certainly some interesting developments. And we could also hear from Eric some follow-up comments in the context of the CTPP, and I would dare to say mega regional treaties as the future of trade and investment protection. So I would like to thank our panelists. I would like to thank Chiara and Monique for moderating this excellent discussion. I would like to thank our attendees for taking some time this morning, afternoon, or evening from their time, and of course to ITA for yet another excellent event. And I would like to welcome everybody to ITA's future events. You have all of them available on the ITA's website. And with this, have a great day, great evening, and see you next time. Thank you very much and goodbye.
Thank you very much.
Thank you. Bye-bye.
Thank you.
Bye.
Bye.